Hello, my name is Paul Fuller, and I'm on the Board of Directors of the American Association of Water Distribution and Management. I'm also an insurance professional that specializes in public water systems. The following presentation is geared specifically to those public water systems that have the power of condemnation, and by extension are vulnerable to inverse condemnation actions. The content reflects my experience underwriting thousands of public water systems and adjusting scores of inverse condemnation claims. It also reflects my reading of the law and my interpretation of how our insurance policies respond to inverse condemnation actions. Notwithstanding, I cannot divine the intent of any other insurance provider's coverage grants or policy mechanics. But what I can offer is reasoned commentary, insurance clarity, and a call to action for public water systems, attorneys, and their insurance providers to discuss inverse condemnation and how it ties back to the insurance policies that were purchased. Inverse condemnation. It's a complex, opaque, and evolving legal theory. It's also confusing because inverse condemnation is not a tort, but a constitutional violation of due process, specifically, the wrongful taking of property without due compensation. To qualify as an inverse condemnation action, a plaintiff just has to connect the dots. And what I mean by that, I'm simplifying it a bit, is the wrongful taking has to result in physical injury to real property proximately caused by a public improvement. A water delivery system is deemed a public improvement. Equally important, a wrongful taking can be temporary as well as permanent. Being a defendant in an inverse condemnation action is a distinct disadvantage. For one thing, the plaintiff doesn't have to prove negligence because inverse condemnation is not a tort. And for another, strict liability applies to most inverse condemnation actions. As a result, public water systems have limited defenses available, with causation being the best available defense. It's also expensive to defend against an inverse condemnation action. Typically, an inverse condemnation action involves two trials, a trial of fact by a judge, and a second trial of damages by a jury. And with inverse condemnation, damages include a plaintiff's attorney fees, expert witness fees, and prejudgment interest. So you blend all those components together, and it's clear that an inverse condemnation action tilts in favor of a plaintiff. And that's by design. The fundamental justification behind inverse condemnation is to protect citizens against the government taking property without due compensation. That purity of purpose has metastasized to a point where it's now commonplace for an inverse condemnation action to be filed against a public water system whenever there's any semblance of physical injury to real property. And the courts have been reluctant to discourage this theory's misuse or overuse, depending on your perspective, because the theory is not based on a tort, but a constitutional violation of due process, a constitutionally protected right that we all have. As a result, inverse condemnation is now being used as a blunt legal instrument to pound public water systems, and to great effect. Even that last bastion of defense, causation, is under attack, which we saw in our case study involving your Belinda Water District. In that situation, a massive wildfire in 2008 destroyed hundreds of homes. The district was sued under the theory of inverse condemnation, and the plaintiff's arguments, simply stated, was the failure of the water delivery system was the proximate cause of loss, as opposed to the wildfire itself. The plaintiffs asserted it didn't matter that the district didn't cause the wildfire, didn't matter that the failure of the water delivery system was the result of the wildfire itself. Instead, they connected the dots. They asserted that the water delivery system, which is a public improvement, failed to protect. And as a result, that constituted a wrongful taking without due compensation. The plaintiffs prevailed under that legal theory of inverse condemnation. And although the decision was non-precedential, it occurred in binding arbitration, it has spurred similar inverse condemnation lawsuits against public water systems arising from the 2017 California wildfires. and we do expect legal precedent to be generated from those court cases. And should the plaintiffs prevail, it will be a further erosion of the defenses available to public water systems as it relates to inverse condemnation. So with that as a backdrop, it's evident that inverse condemnation is an exposure too big to assume for a public water system. It needs to be transferred to a third party. The problem is there's no simple and complete solution to doing that. So what are your options? Risk avoidance? No, that's not going to work. You can't decouple a water delivery system from a public water system. Risk reduction? That's also not viable. There are no legislative or regulatory remedies for a constitutionally protected right. Classical risk transfer through contract? Also not possible unless the public water system chooses to be annexed by another entity, highly unlikely. And so that leaves us with insurance. And although not a panacea, when structured correctly, and underline that 3 times, when structured correctly, insurance can be an effective risk transfer solution for this exposure. However, just buying insurance doesn't equate to automatically receiving inverse condemnation coverage. In fact, most insurance providers explicitly exclude inverse condemnation. Other insurance providers are silent on inverse condemnation, and silence is not an affirmation of coverage. Not with this legal theory, it's too complex. Plus, there are other policy exclusions that can kick out an inverse condemnation claim. It's important that the inverse condemnation coverage is affirmed in writing in the policy. And fortunately, there are some insurance providers that are doing exactly that. They affirm inverse condemnation in writing in the policy, and that's what you need. But even with that option, it requires a review of any restrictions to that coverage grant. It also requires the insertion of your attorney and your insurance provider to discuss the starting and stopping points of the inverse condemnation coverage. It requires a clarity of understanding. So now that we've determined insurance can be an effective risk transfer solution for inverse condemnation, we need to identify the type of insurance policy best equipped to cover the exposure. Would that be the general liability policy or the public officials liability policy? Let's review. A general liability policy includes coverage for property damage claims, among other things, but property damage claims resulting from the products, completed operations, and ongoing operations for which the public water system is legally liable. A general liability policy is triggered off a tort, typically negligence, and it ties back to the public water system's products, completed operations, and ongoing operations. A public official's liability policy is completely different from a general liability policy. In fact, it's structurally more similar to a professional liability policy in that it includes coverage for monetary damages resulting from wrongful acts for which a public water system is legally liable. Examples of wrongful acts would be powers, policies, decisions of the public water system. So let's bring back inverse condemnation. We now know that this legal theory is not a tort. It's not based on negligence. Instead, it's based on a constitutional violation of due process, the wrongful taking of property without due compensation. That wrongful taking comprises the powers, the policies, the decisions of the public water system. It is a wrongful act. And the taking without paying, that's economic injury, otherwise known as monetary damages. So it's clear that inverse condemnation best belongs in a public official's liability policy. The Constitution and case law support that interpretation. The Constitution is also very clear. It states the government can't take property without due compensation, and that's exactly what inverse condemnation is intended to protect against. The taking also involves the lack of compensation, so it's economic injury. Case law further supports this reading. A good example would be Kelly versus Contra Costa Water District 2015. In that ruling, the appellate court confirmed that an inverse condemnation claim, and this is important, an inverse condemnation claim requires the wrongful taking to be based on a policy decision by the public water system and not operational negligence. So we've crystallized that inverse condemnation belongs in the public official's liability policy. But it's important to note lawsuits frequently include multiple causes of action. So an example, a public water system is sued because their water line breaks and that break causes physical injury to real property. It's highly likely that lawsuit will include a cause of action involving inverse condemnation and other causes of action involving negligence, maybe trespass, maybe dangerous condition. Although the facts supporting the lawsuit apply equally to each cause of action, the causes of action themselves are distinct and separate from one another. The cause of action of inverse condemnation is a completely different legal theory than the causes of action involving tort or negligence. Inverse condemnation, again, is that wrongful taking of property without due compensation. It is a wrongful act, and it is based on economic injury, the taking without paying. In this example, the causes of action for negligence involve an operational failure by the public water system resulting in property damage to a third party. I share this example because it's entirely possible your insurance provider will include defense and indemnity for the causes of action involving negligence. Those would be classical coverages comprising the general liability policy. However, with respect to the inverse condemnation action, unless your public official's liability policy affirms inverse condemnation in writing, it is likely you will not have defense or indemnity for that cause of action. That's an important distinction because with causes of action involving negligence, it's a fair fight. You have defenses at your disposal. With inverse condemnation, you don't. There are fewer defenses, hands are to the face, and ultimately, strict liability applies in most instances. To accentuate the gravity of this situation, we go back to the case study involving Yorba Linda Water District. Yorba Linda Water District prevailed under the cause of action involving negligence, but they lost on inverse condemnation, and that was a $69 million judgment. I'd like to conclude our time with my recommendations on how best to structure a public official's liability policy so you receive maximum protection for inverse condemnation actions. There's 5 steps, and they're fairly straightforward. Step 1 is to review the policy exclusions and to see where inverse condemnation is excluded. Typically, inverse condemnation is included in a grouping of exclusions titled public use of property. That would include eminent domain, condemnation, adverse possession, and dedicated use. Those exclusions, in my opinion, are acceptable because they reflect the water system being the provocateur of the action, whereas with inverse condemnation, if it's included in that grouping, it's just the opposite. Inverse condemnation involves the public water system being the recipient of that provocation. Step 2 is to bring back the inverse condemnation coverage through endorsement, and that's best done by a restatement of the public use of property exclusion. The best way to do that is to remove the words inverse condemnation. That provides clarity, it provides affirmation, and it confirms the willingness of the insurance provider to cover inverse condemnation actions. Step 3 is the most important step, and that's to review any restrictions associated with that coverage grant. For instance, do you have coverage for unintended takings, but not deliberate takings as respects to inverse condemnation? If so, it's important to bring in your attorney and insurance provider to discuss the starting and stopping points of the coverage. For instance, would a code violation be deemed a deliberate taking? Would the failure to invest in infrastructure up to an arbitrary baseline be deemed a deliberate taking? What about resources that are prioritized to another neighborhood over another? Would that be a deliberate taking? All of those items need to be codified and clearly articulated so you know exactly where your coverage starts and stops. I've also seen an insurance provider affirm inverse condemnation, but only for the negligence of the public water system. That coverage grant confuses me. Inverse condemnation is not a tort. It's not based on negligence. It's a constitutional violation, as we now know, based on the taking of property without due compensation. And so that coverage grant absolutely requires your attorney and insurance provider to discuss the clarity of understanding as to where that coverage is applicable and how it does apply to inverse condemnation. Step 4 is to seek clarification of the property damage exclusion, which is typical, standard in any public official's liability policy. If you recall, a public official's liability policy includes coverage for monetary damages resulting from wrongful acts. An inverse condemnation action involves wrongful taking. That's deemed a wrongful act. The taking without paying is economic injury or monetary damages. So any resulting property damage would be peripheral to this legal theory. And I'd like to use an example of an engineering firm. If you recall, public officials' liability policies and professional liability policies are structurally similar. So in the event an engineering firm builds a bridge and that bridge collapses because of design error, the proximate cause of loss would be the design error, that professional act, error, or omission by the engineering firm. The property damage is peripheral to that action. Inverse condemnation applies similarly within the public official's liability policy. Finally, it's important to seek clarification as to what is deemed the date of loss for an inverse condemnation action. It is not the date of the lawsuit, but the date the action was originated. It's also important to seek any restrictions associated with manifestation, meaning an inverse condemnation action that occurs over multiple policy periods. And finally, any requirement to provide notice to an insurance provider of an incident that may lead to a future inverse condemnation action. It should also go without mention that your limits associated with inverse condemnation should not be any lower than the public official's liability limit of insurance. There should be no erosion of defense obligation associated with inverse condemnation, and absolutely under no circumstances should you be sharing that inverse condemnation limit with any other entity, member, or insured. That encapsulates my discussion as it relates to inverse condemnation and public water systems that have the power of condemnation. I'd like to leave you with 3 takeaways. Number 1, that call to action for public water systems, their attorneys, and their insurance providers to discuss inverse condemnation and specifically how it ties back to the insurance policies that were purchased. Number 2, the acknowledgement that inverse condemnation is an existential threat to public water systems with the power of condemnation. This exposure is getting worse, not better. The exposure is bigger than your balance sheet. And finally, number 3, the importance of transferring this exposure to a third party. At the moment, insurance is the most practical way to do that, but it requires a properly structured public official's liability policy. Finally, I'd like to leave you with a quote from a plaintiff attorney regarding inverse condemnation. In my opinion, it aptly summarizes the gravity of the situation and the enthusiasm that plaintiff attorneys have regarding this expanding and evolving legal theory. Thank you.